In this video, we will learn about meaning, nature and scope of administrative law. Firstly, introduction. Administrative law is a branch of public law that governs the activities of administrative agencies of government. It encompasses the rules, regulations and procedure created by administrative agencies, which are responsible for the implementation and enforcement of laws passed by legislatures. With the increasing complexity of governance and the expansion of government functions, administrative law has emerged as a vital area of legal study and practice. This essay will explore the meaning, nature, and scope of administrative law. Firstly, meaning of administrative law. Administrative law can be defined as the body of law that regulates the activities of governmental agencies. It includes the rules and regulations that these agencies create, as well as the procedure they must follow when making decisions or enforcing law. Administrative law serves several purposes. First, regulation of agency action. It means it provides a framework for how agencies operate, ensuring that they do so within the bounds of their authority. Second, protection of rights. Administrative law protects the rights of individuals by providing mechanism for challenging agency decisions. Accountability. It holds agencies accountable for their actions, promoting transparency and fairness in government processes. In essence, administrative law is concerned with the relationship between individuals and government agencies, seeking to balance the need for effective governance with the protection of individual rights. Now, nature of administrative law. The nature of administrative law can be characterized by several key features. First, public law. Administrative law is primarily a branch of public law as it deals with the relationship between state and individual. Second, dynamic and evolving. The field of administrative law is constantly evolving in response to changes in society, technology, and governance. As new issues arise, such as those related to environmental issues, data privacy, and public health, administrative law adapts to address these challenges. Third, procedural fairness. A fundamental principle of administrative law is the requirement of procedural fairness, which is often referred to as natural justice. This principle ensures that individuals affected by agency decisions are given a fair opportunity to present their case. Fourth, judicial review. Administrative law provides mechanism for judicial review of agency action. Fifth, discretionary authority. Administrative agencies often possess discretionary authority to make decisions within the scope of their legislative mandate. This discretion allows agencies to adapt their policies and practices to changing circumstances, but also raises concerns about abuse of power. Now we will read about scope of administrative law. First point is regulatory framework. Administrative law governs a wide range of regulatory activities performed by government agencies. These activities include: first is rule making. Agencies have the authority to create rules and regulations that have the force of law. This process often involves public notice and comment periods, allowing stakeholders to provide input on proposed regulations. Second, adjudication. Agencies may conduct hearing and make determinations on disputes involving regulatory compliance or individual rights. Third is enforcement. Administrative agencies are responsible for enforcing law and regulations within their jurisdiction. This may involve inspections, investigations, and the imposition of penalties for non-compliance. Second scope is administrative procedures. Administrative law establishes procedures that agencies must follow when making decisions or taking actions. Key procedural aspects include notice requirements, opportunity to be heard, decision making standards. Third point is judicial review. Judicial review is a critical aspect of administrative law that allows court to examine the legality and reasonableness of agency actions. The scope of judicial review includes standard of review, which means court typically apply different standards when reviewing agency actions, such as arbitrary and capricious or substantial evidence standards. Second, in ground for review. Courts may review agency actions for various reasons, including violations of statutory authority, failure to follow proper procedure, or infringement on constitutional right. Fourth scope is impact on individual rights. Administrative law plays a crucial role in protecting individual rights against potential abuses by government agencies. Key areas include due process, access to information, and judicial remedies. Judicial remedies includes injunctions or damages. Fifth point is administrative discretion. Administrative agencies often possess considerable discretion in how they interpret laws and implement policies. The scope of this discretion raises important questions about accountability and oversights, which includes limit on discretion and policy guidance. Conclusion. In conclusion, administrative law is a vital component of modern governance that regulates the activities of governmental agencies while protecting individual rights. Its meaning encompassing the rules and procedures governing agency action, while its nature reflects its status as a dynamic branch of public law characterized by principle of fairness and accountability. The scope of administrative law is extensive, covering regulatory framework, administrative procedures, judicial review mechanism, individual right protection, and the exercise of agency discretion. As society continues to evolve and face new challenges, administrative law will undoubtedly adapt to address emerging issues related to governance, regulation, and individual rights. Understanding the meaning, nature, and scope of administrative law is essential for legal practitioners, policymakers, and citizens alike as they navigate the complexity of government action in a democratic society. Thank you for watching this video.